Welcome to the Insurance Agents and Brokers Podcast.
Hello everyone, I hope you're all doing well, that you've all had an enjoyable summer, and that you can find it in your hearts to embrace the fact that autumn is just around the corner. Let me introduce myself. I'm Don Bankus, IA&B's Legal and Corporate Affairs Director, and I'd like to welcome you to the September 2023 edition of Primary Agent Magazine's Don's Discussions. So without further ado, let's get to this month's Q&A. This month's question is, due to some possible miscommunication during renewal, one of my insureds ended up incurring a cost he feels is the agency's fault. While I don't necessarily believe it's the agency's fault, I do feel bad and reimburse the customer $350 to help cover the cost. Is this okay? I know you've heard the saying, no good deed goes unpunished, so while your intent in paying a fine or a towing fee or helping with a deductible may genuinely be to improve an otherwise unfortunate or uncomfortable situation, or simply to try and make the customer whole again, the regulators in our 3 states may view your actions differently, not as an act of kindness and consideration, but rather as a violation of the respective states' rebating laws. So you ask, how might my state view such an act? In Delaware, under the above scenario, applicable Delaware law provides little or no leeway and would prohibit such an act. While Delaware's producer licensing statute is silent on the issue, Delaware's unfair practices in the insurance business statute is unequivocal, and at 18 Delaware Code Section 2304-15, it provides that no property, casualty, or surety insurer or any employer or representative thereof, and no broker, agent, or solicitor shall pay, allow, or give, or offer to pay, allow, or give, directly or indirectly, as an inducement to insurance or after insurance has been effected, any rebate, discount, abatement, credit, or reduction of the premium named in a policy of insurance, or any special favor or advantage in the dividends or other benefits to accrue thereon, or any valuable consideration or inducement whatsoever not specified or provided for in the policy, except to the extent provided for in the applicable filing with the Commissioner as provided by law. In Maryland, it's pretty much the same thing. Again, as it relates to the above scenario, the applicable Maryland law provides little or no leeway and would prohibit such an act. The issue is governed by Maryland's Unfair Trade Practices and Other Prohibited Acts statute at Maryland Code Insurance, Section 27-212, which provides, except to the extent provided for in an applicable filing with the Commissioner as provided by law, an insurer, employee, or representative of an insurer or insurance producer may not pay, allow, give, or offer to pay, allow or give directly or indirectly as an inducement to insurance or after insurance has become effective, 1, a rebate, discount, abatement, credit, or reduction of the premium stated in the policy, 2, a special favor or advantage in the dividends or other benefits to accrue on the policy, or 3, any valuable consideration or other inducement not specified in the policy. So under Maryland law, you're not allowed to give that $350 back. Pennsylvania. Generally speaking, Pennsylvania's anti-rebating provisions are as restrictive as and essentially mirror those of Delaware and Maryland as just provided to you. However, in 2018, Pennsylvania amended a portion of its Pennsylvania Producer Licensing Act to include the following exception to its anti-rebating provisions. Exception: an insurance producer may offer or give to an insured or a prospective insured on an annual aggregate basis, which would be on a calendar year basis, any favor, advantage, object, valuable consideration, or anything other than money that has a cost or a redeemable value of less than or equal to $100, which is not specified in the contract of insurance. Accordingly, under the above scenario in Pennsylvania, it would be permissible for an agency to provide the insured with a gift card with a value of no more than $100, keeping in mind that the statute does not allow for payment in cash. However, notwithstanding the $100 allowance, as is the case in Delaware and Maryland above, it would be a violation of Pennsylvania law if you were to reimburse the customer the total amount of $350 as originally referenced in the scenario. Okay, so what are the potential penalties for violating the law in these 3 states. In Delaware, a licensee is subject to a fine of up to $1,000 for each violation, not to exceed $100,000, as well as possible suspension or revocation of one's producer license. Delaware statute can be found at 18 Delaware Code Section 2308. In Maryland, a licensee is subject to a fine of between $100 and $500 per violation, as well as possible suspension or revocation of one's producer license. Maryland statute can be found at Maryland Insurance Code, sections 27-209 through 212. In Pennsylvania, a licensee is subject to a fine of up to $5,000 for each violation, as well as possible suspension, refusal to renew, or revocation of one's producer license. Pennsylvania statute can be found at 40 Purdon Statutes, section 310.91. Final thought. While it hardly seems fair or equitable that simply trying to rectify a possible error committed by the agency for the benefit of a customer could somehow be a violation of law, the reality is you could end up in hot water if you engage in such a practice. And there you have it. If you have any questions, please feel free to reach out and contact me at 800-998-9644 at extension 603, or email me at donb@iabforme.com. Thank you very much for listening. Hope you have a great day, and please continue to be well and safe.
Insurance Agents and Brokers is the premier resource and champion for independent insurance agencies in Pennsylvania, Maryland, and Delaware. For more information, visit iabforme.com. This is not a legal opinion and should not be relied upon as such. The intent is to provide general background regarding the topics discussed, not to provide legal advice. Producers and agencies should consult an attorney regarding specific situations and questions with respect to the topics covered. Neither IA&B or any of its employees shall be responsible for any errors or omissions regarding any statements, nor any statutes, regulations, court rules, and/or government documents cited.